Welcome back to Law and Legal Process. I'm your Professor Shane Nelson, and today we're continuing our discussion of tort law. So this is obviously one of the larger areas of civil law in the United States, and in the last lecture we just covered a bunch of different things about tort law, how it provides a legal remedy for one person who is wrongfully injuring another person. But today we're going to be diving in a little bit deeper and asking the question of if every injury deserves compensation. Because some of these things do seem straightforward, such as physical injuries. Say if somebody is just negligently running a red light and they break your leg, well, the law is generally going to allow you to recover compensation. But let's say that your injury is purely emotional. What if the newspaper publishes false information that destroys your reputation? What if a jury awards millions of dollars against a physician, but the legislator says that the amount is simply too high? Well, these are all of the different questions that we're going to be looking at in three important appellate decisions of case law today. So we're going to begin by briefly just reviewing the foundations of tort law that we covered last lecture, and then we're going to return to the three cases that demonstrate how the courts balance fairness, public policy, and the constitutional principles when determining civil liability. So let's begin with the basics. A tort is a civil wrong other than a breach of contract that causes injury to another person and gives rise to a lawsuit seeking monetary damages or another civil remedy. The person committing the wrongful act is called the tortfeasor. And Schubert emphasizes how tort law is distinct from contract law because liability arises not from a broken promise, but from a breach of legal duty owed to another person. And unlike criminal law, tort law is generally concerned with compensating victims rather than trying to punish the offenders. So think about things like instead of imprisonment or probation, the typical remedy here is going to be monetary value, right? So money damages that are designed to restore the injured person as nearly as you can. You'll also notice that tort lawsuits use different terminology than criminal prosecutions. The injured party is always called the plaintiff, while the person accused of causing the injury is the defendant. Now, before we get into some of the additional cases that we're going to be discussing today, I wanted to provide you with some more context. So, for much of American legal history, the courts generally refused to award damages for pure emotional distress. And this is obviously because emotional distress is hard to gauge and allocate damages for. So, under the traditional impact rule, a plaintiff could only recover if they suffered some sort of physical impact during the accident, and emotional distress by itself was just simply not enough. Like I mentioned before, I'm probably wondering why the courts even adopted this rule. Well, they did have three primary reasons. The first, like I said before, it's that emotional injuries are difficult to gauge and hard to prove, and unlike things such as a broken bone, emotional trauma can't really be seen on an X-ray, so the courts worried about fraudulent or just over-exaggerated claims. Second, the judges feared unlimited liability. So imagine if you have a train derailment in the middle of a city, and hundreds of bystanders might witness this horrific accident. Now, what if everybody who just watched the train derailment, can they all sue for emotional distress? And where would the liability end here? And lastly, the courts wanted a clear and objective rule. And physical impact created the bright line test that judges could apply consistently. But the problem, however, is that the rule often produced harsh results. So parents who watched a child die, spouses who witnessed catastrophic injuries, or siblings who experienced profound emotional trauma could be denied recovery simply because they themselves were never physically touched or hurt. And that's why I included the Little Mac in the Soda Popinski, like old school Nintendo reference here. So just imagine Soda Popinski knocks out your best friend while you're standing on the ringside, and you witness everything. You witness this assault, and you're emotionally devastated, but you weren't the one who got punched. So under the traditional impact rule, that emotional distress alone would not be enough to recover any damages. So as medicine and psychology advance here, the courts increasingly recognize that emotional trauma can be just as real as physical injury. And this realization set the stage for the case of Clohessy v. Bachelor, where the courts actually started moving away from the strict impact rule. The case of Clohessy v. Bachelor arose when a young child was struck and killed by a motor vehicle, and the close family members witnessed the accident and came upon the immediate aftermath almost instantaneously, although they didn't suffer any physical injuries themselves. But as you can imagine, the emotional consequences of just witnessing the death of your child, that's going to be something that's so profound, I can't even put it into words. So the family alleged that witnessing the violent death of their loved one caused them severe psychological trauma, and they sought compensation for the negligent infliction of emotional distress. Now, at first glance here, this claim appears to be very reasonable. If another person's negligence causes devastating emotional injuries, then why shouldn't those injuries be compensable? Yet the Connecticut Supreme Court recognized that this question carried enormous implications. A decision that allows recovery too broadly could just dramatically expand tort liability, and a decision that denies recovery entirely ignores the overall modern understanding of psychological trauma. So the court had to determine where to draw the line in this case. The legal issue in this case is, can a bystander recover damages for emotional distress caused by witnessing serious injury to a loved one? So notice that the court is not deciding whether or not emotional distress is real. The modern psychology had already answered that question. Instead, the court is really just deciding how far tort liability should extend in this case. If the parents can recover, then what about the grandparents? What about close friends, teachers, neighbors, bystanders that also saw the accident? So every expansion of liability is potentially just creating more justice for deserving plaintiffs, but it also creates a greater financial responsibility for the defendants in these cases. So the courts consistently have to juggle all of these and try to balance the competing concerns. Now, in this case, the court said yes, recovery is allowed, but only under carefully limited circumstances. So the court in this case adopted a carefully tailored rule that was designed to compensate truly foreseeable victims while preventing just endless amounts of litigation. The courts recognize that the parents watching their child suffer catastrophic injuries is fundamentally different than a stranger that reads about the same accident in the newspaper. So one situation involves a deeply personable and foreseeable emotional injury, while the other does not. And rather than opening the courthouse doors to everyone, the court established several different requirements that plaintiffs must satisfy before recovering any damages, and these requirements remain highly influential even in cases today. So this brings us to the Clohessy test. A plaintiff generally has to show a close family relationship, contemporaneous observation, serious injury or death, serious emotional distress. So when we look at these, first, the plaintiff has to have that close familial relationship with the injured victim. So the courts generally limit recovery in these cases to people like the parents, children, spouses, and similarly just close family members because emotional harm is most foreseeable within these relationships. Second, the plaintiff must witness the event as it occurs or immediately afterwards while the traumatic scene is still unfolding. And this ensures that the emotional injury results directly from the accident rather than from learning about it hours or days later. Third, the victim must suffer death or serious physical injury, so minor accidents ordinarily are not going to justify recovery for the bystander emotional distress. And finally, the plaintiff must demonstrate serious emotional distress, not just ordinary grief or sadness, but it has to be a psychological harm significant enough that a reasonable person would be unable to cope with it. Now, in this case of Clohessy, just notice what the court is accomplishing here. It's expanding tort liability beyond the old impact rule of physical harm, right? So notice here that it's creating a meaningful limit catered to preventing unlimited lawsuits. So in many ways, Clohessy reflects one of the central themes of tort law, that the courts seek to compensate genuine injuries while also drawing principled boundaries around civil liability. Now, as you can imagine, after Clohessy, we've seen tort law expand to recognize new categories of injuries. So the next question naturally became whether the courts were awarding too much compensation. Now, beginning around the 1970s and continuing into the early 2000s, many of the states argued that they were facing what became known as a medical malpractice insurance crisis. Now, a lot of the physicians and hospitals claimed that jury verdicts in malpractice cases were becoming increasingly unpredictable, and this was particularly when juries were awarding just substantial amounts of money for a person's pain and suffering. And unlike medical bills or lost wages, which can be calculated with relative precision, non-economic damages, such as emotional suffering, loss of enjoyment, or permanent disfigurement, these are all relatively just subjective things. It is inherently subjective because what you consider to be emotional suffering might not be the same extent of suffering to another person. So two juries can be presented with nearly identical facts and they might award dramatically different amounts that are a couple standard deviations away from one another. So the whole point of this is that the medical organizations were arguing that these large verdicts are causing malpractice insurance premiums to skyrocket, and they're warning that the physicians would retire early, they're going to relocate to states with more favorable laws, or they're going to avoid high-risk specialties such as neurosurgery, for example. So some policymakers even argue that the patients would ultimately suffer because if you have fewer physicians, they're not going to be able to provide you with the meaningful care that you need. And in response to this, many of the state legislators enacted tort reform measures, including statutory caps, which limited how much plaintiffs could recover for non-economic damages. So supporters viewed these reforms as necessary to stabilize a lot of the healthcare costs, and a lot of the opponents just argued that they unfairly limited compensation for the more seriously injured patients. And this growing national debate set the stage for the case of Atlanta Oculoplastic Surgery v. Nestlehutt. The dispute in Atlanta Oculoplastic Surgery v. Nestlehutt, which I'm just going to refer to as Nestlehutt because I'm not saying that each time. So this case arose after a patient underwent elective cosmetic surgery. And rather than improving the patient's appearance, Nestlehutt's appearance, the procedure allegedly resulted in significant and permanent injuries. And Nestlehutt claimed that the physician essentially had failed to meet the appropriate standard of medical care and filed a medical malpractice lawsuit seeking compensation as a result of the botched surgery. Now, after hearing the evidence, the jury concluded that the malpractice had occurred and awarded Nestlehutt economic damages such as medical expenses and non-economic damages, including compensation for pain, suffering, and permanent disfigurement. Now, ordinarily, the jury's verdict would conclude the case. However, Georgia had enacted a tort reform statute that placed a statutory ceiling on non-economic damages in medical malpractice cases. And because of this statute, the trial judge was required to reduce the jury's award, even though the jury had already determined that the higher amount represented fair compensation based on the evidence available. The plaintiff, Nestlehutt, challenged that reduction, arguing that the legislator had improperly interfered with the constitutional role of the jury. And so this brings us to our key legal question here. Can the legislator limit a jury's damage awards in a medical malpractice case? So notice that the case isn't really about whether or not the physicians committed the malpractice that's already been decided. Instead, it's one of constitutional authority. So essentially, who has the final say when determining damages in a civil lawsuit? Should elected legislators establish fixed limits that apply to every case, or should juries evaluate each plaintiff individually and then decide what amount is fair based upon the specific evidence that's presented at trial? So, of course, you'll have some supporters of the statutory caps that are going to argue things like that the legislators, they need to establish public policy, and therefore they possess the authority to regulate civil liabilities. And then opponents are going to respond to this and say that, well, people should have the right to have damages determined by a jury because it's one of the oldest protections in Anglo-American law, which dates back hundreds of years. And once a jury has carefully evaluated the evidence, the legislator shouldn't just simply substitute their own judgment for that of the citizen who actually heard the case. So the Georgia Supreme Court had to decide not only a question of tort law, but also one involving constitutional separation of powers. The Georgia Supreme Court ultimately struck down the statutory cap. The court emphasized that the Georgia Constitution guarantees the right to a trial by jury, and historically, determining damages has always been one of the jury's fundamental responsibilities. So jurors listened to the testimony in this case, they observed the witnesses, they evaluated the credibility of the claims, and at the end, they ended up determining what amount of compensation fairly reflected Nestlehutt's injuries that she suffered. So the court here is reasoning that once a jury has already fulfilled that constitutional function, the legislator can't just simply replace the jury's judgment with an arbitrary statutory maximum, right? And again, an example here, imagine if you have two plaintiffs. One suffers a relatively minor scarring after surgery, and another, let's say they suffer a catastrophic disfigurement, a facial disfigurement or something that requires multiple reconstructive procedures and lifelong psychological treatment. Well, let's say if we had a rigid damages cap in place, both plaintiffs could potentially just receive the same maximum award for non-economic damages, despite having vastly different injuries. So the Georgia Supreme Court here is concluding that such a result, in the case of Nestlehutt, ultimately undermines the constitutional role that's assigned to juries. So in closing, the case of Nestlehutt illustrates that if nothing else, tort law is often about much more than just compensating an individual person, right? Every malpractice lawsuit also raises broader questions about healthcare policy, insurance markets, physician availability, and constitutional government. So even today, if we have states that remain deeply divided over different damage caps, some jurisdictions will still continue to enforce statutory limits on non-economic damages, while others, like Georgia in the case of Nestlehutt, have invalidated similar statutes under their own constitutions. So reasonable people will still continue to disagree about the proper solution here, and supporters of the tort reform will definitely argue that predictable liability promotes affordable health care and prevents excessive litigation. And of course, you'll have critics that respond that arbitrary limits disproportionately affect some of the more severely injured patients, because individuals that have these catastrophic lifelong injuries are often going to rely heavily upon non-economic damages to achieve any sort of meaningful compensation. So it's an ongoing debate that just really demonstrates how tort law is not merely about legal doctrine, and it definitely reflects just competing ideas about fairness, economics, the structure of our Constitution, and of course the proper role of the courts and legislators in American society. So issues such as the caps on non-economic damages, this became a central feature in modern tort policy, and it really does stem from this case of Nestlehutt, which served as a prominent example of judicial review of the legislative reform efforts. So far in today's lecture, we focused primarily on physical and emotional injuries, but tort law protects something else that is incredibly valuable, that being your reputation. So imagine you're applying for your dream job, you got the LinkedIn ready, you've got your degrees, you're ready to go, and then later on you find out that your employer discovers an article falsely accusing you of, let's say, an academic fraud or a financial crime, okay? Even if both of these accusations are completely false, the damage to your reputation could cost you employment opportunities, friendships, business relationships, and years of you just trying to rebuild your name. So the law recognizes that a person's reputation has real value, and that's why defamation is considered an intentional tort. Now, at the same time, however, the First Amendment strongly protects freedom of speech and, of course, the freedom of the press, and journalists regularly will report on controversial issues involving our politicians, as we all know, celebrities, athletes, and other public figures. And honest mistakes do happen throughout these processes, but here the challenge for the courts is really balancing the two competing interests of journalistic integrity and then outright defamation. So how can we still protect individuals from false and defamatory statements without discouraging journalists from reporting on matters that are still of public concern? And that constitutional balancing act lies at the heart of our next case, that being Curtis Publishing Co. v. Butts. So the controversy began in 1962 when the Saturday Evening Post, one of the nation's most widely read magazines, published an explosive article accusing former University of Georgia football coach Wally Butts, unfortunate name, of conspiring to fix a football game. So according to the magazine by the Evening Post, Butts had shared confidential information with the Alabama coach Paul Bear Bryant before a highly anticipated game, which essentially gave Alabama an unfair competitive advantage. So for a respected coach, whose career obviously depends upon your integrity, these accusations were devastating. And if true, they suggested that Butts had been cheating, he was dishonest, and it was a betrayal of both his university and the sport of football itself. Butts vehemently denied these allegations and argued that the magazine had published a story without adequately verifying anything. So he claimed that the publication relied on questionable sources, they had failed to properly investigate the allegations, and they ignored obvious reasons to doubt the story before publishing it nationwide. And as a result, Butts filed a defamation lawsuit seeking potential damages for the harm to his own personal reputation. This case raised a constitutional question that had become increasingly important after the Supreme Court's landmark decision in the New York Times Co. v. Sullivan. So, the New York Times, the court had held that the public officials could not recover damages for defamatory statements unless they could prove that the publisher acted with actual malice. So, notice that actual malice is a legal term of art. I'm going to be going over this a little bit later to define these. But actual malice, it doesn't mean hatred, personal spite, or ill will. For a publisher, actual malice would exist if a publisher either knows that a statement is false or they're just acting with reckless disregard for whether or not the statement is true or false, okay? So the question in Curtis Publishing was whether or not this demanding constitutional standard should apply to only elected government officials or whether or not it should also extend to other individuals who occupy prominent positions in public life. For example, famous coaches like Butts, and then also other people you could be affecting like entertainers, business leaders, or even celebrities. In this case, the United States Supreme Court concluded that the actual malice standard could not be limited solely to elected government officials. Instead, the court held that public figures also bear the burden of proving actual malice when suing for defamation. Now, why is this? Well, the court reasoned that many public figures voluntarily place themselves into the public spotlight, and they often enjoy greater access to media, giving them more opportunities to respond to false allegations. They also influence matters of public concern and therefore become appropriate subjects of public discussion. And even more importantly, the court feared that allowing public figures to easily win defamation lawsuits would discourage journalists from investigating controversial issues. So reporters might avoid publishing legitimate stories simply because they're in fear for enormous financial liability if they make an honest mistake. And by requiring the proof of actual malice, the court attempted to encourage robust public debate while still allowing recovery in situations involving truly irresponsible journalism. Now, although Curtis Publishing was decided in 1967, it seems like a long time ago, its importance has only grown throughout our own digital age, and that's mainly because information spreads around the world in seconds, and we have so many different media platforms like X, Twitter, whatever you call it, Instagram, Facebook, TikTok, and YouTube, and so we have these news organizations with just so many bloggers, influencers, podcasters, and citizen journalists, all of whom might reach millions of views almost instantly, and so just consider how quickly potentially false accusations can circulate online. And if you have a misleading tweet or a AI-edited video or a fabricated story that could potentially damage someone's reputation before corrections are ever issued. So this is why the case is of paramount importance. And naturally, at the same time, aggressive defamation lawsuits could also discourage journalists from reporting on corruption, government misconduct, or powerful public figures' corruption. So the constitutional balance that's established in this case of Curtis Publishing continues to shape virtually every major defamation case involving our politicians, celebrities, athletes, media organizations, and online personalities. Now, very quickly, I just wanted to go over the actual malice versus negligence, because this is something that students often confuse negligence with actual malice, but they are fundamentally different legal standards that you should be aware of. So negligence is just simply asking whether a person failed to exercise reasonable care, and actual malice is much more demanding constitutional standard. The plaintiff has to prove that the publisher either knew that the statement was false when it was published, or acted with reckless disregard for whether it was true or false, like I stated earlier. That's the difference between actual malice and negligence, and it is a crucial distinction because public officials and public figures cannot recover damages merely by showing that a reporter had made an honest mistake. You have to prove that actual malice, and that's a heightened burden to protect vigorous public debate and investigative journalism, because as it turns out, when you investigate things and you're trying to unearth evidence, you do get a lot of things wrong. There are a lot of misconceptions with this. So I believe that's important, and I want you to just genuinely take away the difference between the two of these. Now, although today's cases involve very different factual situations, all of them are asking the same fundamental question: where should tort liability end? In Clohessy, the Connecticut Supreme Court expanded recovery for emotional injuries, but carefully limited who could sue. In the case of Nestlehutt, the Georgia Supreme Court protected the constitutional role of juries in determining damages, while rejecting legislative limits on compensation. And finally, in Curtis Publishing, the United States Supreme Court recognized that reputational injuries deserve protection, but it also strengthened constitutional protections for freedom of the press by requiring public figures to prove actual malice. And notice that none of these courts adopted absolute rules. Like I said, some of them do vary by state. Instead, each attempted to balance competing values: fairness to an injured plaintiff, constitutional protections, and broader public policy concerns. So as we conclude today's lecture, I want you to notice that tort law is not simply about deciding who wins and who loses a lawsuit. It's about determining where society should draw the boundaries of civil responsibility. And the three cases that we discussed today illustrate all of these boundaries from different perspectives. Clohessy teaches us about emotional injuries, but the courts do have to establish principal limits on recovery. Nestlehutt reminds us that questions about damages are not merely economic, but they also implicate constitutional principles, including the right to a trial by jury. And finally, the case of Curtis Publishing demonstrates that balancing an individual's reputation must always be balanced against the First Amendment's commitment to free and open public debate. And so when we take all of these together, these decisions reflect the central purpose of tort law, essentially compensating genuine injuries while carefully balancing fairness, constitutional rights, and broader public interest. But with all of this said, I conclude today's lecture. If you have any questions for me, feel free to email me. But until next time, take care.